The nation's top law enforcement officer, the person sworn to uphold the Constitution, suddenly acting like nothing more than the president's personal lawyer. That's exactly the charge Congressman Jamie Raskin leveled in a fiery confrontation with Attorney General Pam Bondi. He accused her of twisting the Department of Justice into a private law firm for one man and one political party, an act he called a remarkable defamation of American history. Think about that. The DOJ, an institution built to defend the rule of law, reduced to defending only the interests of one president. Raskin's warning was clear: when an attorney general abandons her independence, democracy itself is at risk.
Party of your state. And I just wonder if you would say a word about what it means to you to be an attorney general and to try to act on behalf of the rule of law and not a political program. Perhaps Attorney General Rowell, if you'd start.
Thank you for that question. I serve as the Attorney General of the state of Illinois, and in Illinois, I am independently elected from the governor, and by way of that, I serve the rule of law. I don't serve the governor. I do represent the governor. I represent the agencies within state, but I serve the rule of law, and I take that distinction very seriously, and I think that the U.S. Attorney General should operate with the same sort of, she shouldn't be loyal to the president, but she should be loyal to the rule of law. That does not mean you're not representing the government and the administration, but you have to do so within the bounds of the rule of law, and we take that very seriously.
Is there any one of you who would describe your job as being the governor's lawyer? Exclusively, in any way, okay. So I don't know if anybody wanted to add anything else on this. Yes, Attorney General Campbell.
I'll just add, similar in Massachusetts, elected by the people, and I'm accountable to the people in upholding the rule of law and protecting their rights and protecting our state's economy. I would just stress, and I think the NIH case, which we were all a part of, whether it's the first case or even the second iteration of that case, to protect access to these critical life-saving medical research, clinical trials. This is billions of dollars that go to every state in the country. We came together not looking at, okay, how do we just protect those who are Democrats or identify as Democrats in this country? We came together recognizing the unlawful actions by this administration to cut that funding. NIH won quickly on a Friday night and mobilized to show up in court on Monday because we knew what was at stake. When you talk about a child having pediatric cancer or a vet dealing with PTSD, we don't look at whether or not they have a D or an R by their names. We mobilize to advance that litigation to protect the public health, not even only of those folks in our state, but to protect the public health of everyone across this country while at the same time upholding the rule of law. And I think it's just a great example of a great example of how we do our work regardless of political affiliation or even demographic.
Well, thank you for doing that. And Ellison and Plotkin, let me just twist the question a little bit. One of the things you guys are doing is defending the integrity of federal laws and programs that we've adopted. And because of the very restrictive standing rules that the court has imposed against Congress going to court to try to get our laws implemented, in a weird way, you're standing up for the laws that we've participated in passing. But that's for all of the people, because after all, it's your representatives in Congress who voted for them as well. But I wonder if you could just reflect a little bit on that role you're playing in terms of making federal law work for everybody in the country as a state attorney general.
Chairman Raskin, we regard the laws that Congress passes as fundamentally the prerogative of the people who populate this country and send members to Congress. And so for an executive to usurp the role of Congress in appropriations or establishment of agencies or anything like that, we view as an outrageous overreach that simply cannot be tolerated. As I noted in my comments, the things that the president is trying to do, you probably can do if you follow the rules, but you cannot do it vis-a-vis executive order or edict or proclamation or this is how I feel this morning. The fact is that there are procedures that they can follow. They got to go to Congress. You want to abolish the Department of Education, as horrible of an idea as I believe that is, you have to go through Congress to do that. So he's not only doing things that I think are harmful to the American people, he's doing them in a way that is harmful to our system of justice and democracy.
Great. And then finally, forgive me.
I was just going to note, Representative Raskin, that what you said at the start of this is the core of many of the lawsuits we filed. Article 1 gives this body the broadest powers, particularly when it comes to passing laws.
This wasn't partisan bickering, it was a fundamental question of whether the United States still honors the separation of powers or slides into unchecked loyalty. And what happened next made the stakes even clearer, as state attorneys general stepped in with their own explosive testimony that put Bondi's actions in stark contrast. Congressman Jamie Raskin wasted no time drawing a sharp line in the sand. He looked directly at Pam Bondi and accused her of abandoning the very foundation of her office. Instead of serving as the nation's attorney general, Raskin said Bondi had chosen to act as the president's personal lawyer. He described it as nothing less than a collapse of constitutional duty, a transformation of the Department of Justice into a political shield for one individual. To Raskin, this wasn't simply a matter of politics, it was a betrayal of the rule of law itself. Raskin's tone carried urgency and frustration as he explained how dangerous this shift was. An attorney general, he argued, must be independent, impartial, and bound only by the Constitution. By reducing her role to personal loyalty, Pam Bondi had undermined public trust in the nation's top legal institution. The stakes, he insisted, could not be higher. When the justice system bends to one person's will, democracy itself is placed in jeopardy. His words were a direct challenge, and they set the stage for a larger clash about what it truly means to be the guardian of law in America. While Jamie Raskin laid out his blistering critique, state attorneys general stepped forward to show what real independence looks like. The Attorney General of Illinois made it clear that unlike Pam Bondi, he was not there to serve any politician. He explained that in Illinois, the office is elected by the people, and that distinction means loyalty belongs to the Constitution and the rule of law, not to a governor or party line. His words drew a striking contrast. Where Bondi was accused of shrinking her role to a personal advocate, others emphasized that their duty was to every citizen, regardless of political affiliation. Massachusetts Attorney General Andrea Campbell echoed that same principle. She reminded the committee that her role was about protecting rights, safeguarding the state's economy, and ensuring public health. She pointed to the fight over NIH funding, where attorneys general had to act quickly to defend medical research vital to cancer patients and veterans battling PTSD. In moments like that, she stressed, no one asked who a Democrat or Republican was. The mission was about saving lives and defending the law. Together, their testimony painted Pam Bondi's approach as an outlier, far removed from the standards of genuine public service. The testimony from Massachusetts Attorney General Andrea Campbell drove the point home with even greater urgency. She explained that her role was never about serving a political figure, but about being accountable to the people who elected her. Unlike Pam Bondi, who had been accused of turning the Justice Department into a shield for one person's interests, Campbell emphasized that her duty was rooted in defending the public good. She spoke of moments when state attorneys general had to move overnight to block reckless actions that threatened vital programs. One striking example was the sudden attempt to slash NIH funding, which directly supported life-saving research for pediatric cancer patients and veterans battling PTSD. Campbell described how attorneys general came together across state lines, not to protect a party label, but to protect families who depended on those treatments. She underlined that when lives are at stake, politics has no place in the courtroom. Her words carried a powerful contrast. Where Pam Bondi was criticized for blind loyalty, others had mobilized for public health, scientific integrity, and the broader rule of law. It was a reminder that the office of Attorney General is meant to safeguard people, not serve political convenience. As the hearing continued, the discussion turned to the abuse of executive power and the dangers it posed to constitutional order. State attorneys general explained that presidents may feel entitled to act unilaterally, but the law provides clear limits. They described attempts to bypass Congress through sweeping executive orders and sudden decrees, warning that such behavior resembled rule by edict rather than governance under law. Congressman Raskin sharpened the point with a vivid metaphor. This was not the conduct of a public servant, but the posture of a king. Pam Bondi's name surfaced repeatedly as the example of what happens when an attorney general enables that overreach instead of restraining it. By defending questionable executive actions, she was accused of abandoning the independence her office demanded. Instead of standing as a guardian of checks and balances, Bondi was portrayed as legitimizing authority that had no legal basis. The state attorneys general, by contrast, insisted that their duty was to push back, to remind the executive that laws are passed by Congress and cannot be rewritten on a whim. The contrast was stark. Where Pam Bondi appeared to normalize unilateral power, others fought to keep democracy anchored in the rule of law. The attorneys general then shifted the conversation to the heart of the Constitution, Article F, the powers of Congress. They reminded the committee that spending, lawmaking, and the creation of federal programs are the prerogatives of elected representatives. Any attempt to sidestep those powers, they argued, is not only unlawful but corrosive to democracy itself. Laws are passed by Congress, signed by presidents, and meant to serve the people. For an executive to unilaterally rewrite or redirect them is a breach of trust and a violation of constitutional order. This was where Pam Bondi's actions drew the sharpest contrast. Instead of defending Congress's authority, she was accused of enabling its erosion. By aligning herself with executive maneuvers that bypassed the legislature, Bondi positioned herself against the very institution she was sworn to uphold. State attorneys general made clear that their lawsuits weren't about partisanship, they were about defending Congress's rightful role. Whether it was blocking the misuse of highway funds for unrelated purposes or stopping sudden cuts to research programs, they saw themselves as defenders of the people's voice in government. Against that backdrop, Pam Bondi's posture looked less like leadership and more like complicity in undermining democratic balance. The final stretch of testimony carried a powerful moral weight. Congressman Raskin reminded the room of Benjamin Franklin's words, "Wrong grows worse until it can no longer be endured, but right always prevails in the end." It was a call to see this battle not just as a legal dispute, but as a defining test of American democracy. The attorneys general echoed that sentiment, pointing to the human cost of these fights: children needing cancer treatment, veterans grappling with PTSD, families relying on federal programs to survive. For them, the rule of law was not an abstract principle, it was a lifeline for ordinary people. Against this backdrop, Pam Bondi's record stood in stark opposition. By aligning herself with executive overreach, she was accused of disregarding both constitutional boundaries and the lives those laws were meant to protect. The state attorneys general made clear that their work was about defending everyone, regardless of party or politics. In contrast, Bondi's critics argued that her loyalty narrowed to a single figure, leaving the public vulnerable. Raskin framed it as a systemic crisis, warning that the nation's future hinged on whether its leaders would follow the path of law or repeat the mistakes of blind allegiance. As the hearing drew to a close, one theme rose above all others: the difference between loyalty to law and loyalty to power. Congressman Raskin's confrontation left no doubt that Pam Bondi had become the symbol of what happens when an attorney general abandons constitutional duty. Again and again, her name was raised as the cautionary example of an office holder who chose allegiance to a single individual over the people and the Constitution she swore to serve. By contrast, state attorneys general underscored that their authority comes from the public, and their responsibility is to the rule of law. They showed how real leadership means standing up for Congress's authority, defending life-saving research, and protecting citizens without regard to party. Their testimony revealed that when one attorney general like Pam Bondi narrows her mission to personal loyalty, it takes others across the country to hold the line. In the end, the clash was unmistakable. Pam Bondi's path represented the erosion of independence, while her counterparts offered a vision of accountability and principle. Raskin framed the moment as a constitutional crisis, a warning that the survival of democracy depends on whether the nation chooses law or yields to loyalty.